David Freiberg will be kicking us off from our incident management unit. David, it's in your hands now.
All right, thank you, Davin. Good morning, and thank you for everyone attending this 2024 summit session. First, we're going to speak about taking the report. So the Justice Center operates a 24/7, 365-day hotline in which our agents take reports of abuse and neglect for vulnerable persons. There's also a few other ways to report an incident to the Justice Center, such as our web forms, which are located on our public website. And we also accept emails as well as regular U.S. postal mail. And just to get into the reports, mandated reporters must report reportable incidents involving vulnerable persons. So someone might be asking what a mandated reporter is. And a mandated reporter is can be defined as a human service professional or a custodian. And some of those human service professionals include social workers, medical professionals, and psychologists, just to name a few. And then our custodians are defined as directors or operators, employees, and volunteers that have substantial contact with individuals and provide services to those. And then just in 2023, we had 13,045 reports of abuse and neglect, and then 27,869, which were significant incidents. All right, so when the report is made, a trained representative collects information from the reporter and gives the caller an incident number. This incident number is very important because that's your confirmation for making this report. And if you're the original reporter and you would like to call back and update that report you made, you're going to need that confirmation number. And it starts typically with a 101 and then a rather long, large number. If you were to call our hotline and ask to update your report, our agents are going to ask you for that incident number, and then they're going to ask some demographic information about the caller, perhaps their name, their date of birth, a phone number associated with them, or an email address. And that's going to ensure that the original reporter is in fact on the line looking to update that report. Our reporters are protected by confidentiality laws, and all calls are recorded and monitored for quality assurance, and we retain those for a period of 180 days. So just some of the information that we're going to be asking while we're on the phone is some details regarding the victim, subject, and witnesses, details of the incident, including the date, time, location, and description of the incident. The responsible state oversight agency, is that going to be the Office for People with Developmental Disabilities? Is that going to be Office of Mental Health, State Education, Office of Children and Family Services, a very small sliver of Department of Health, or our Office of Addiction Services and Supports. We're going to be looking for the name and the address of the provider. Confirmation that immediate protections are in place for the victim, and that is one of our most important questions that we're going to be asking you. The last thing that the Justice Center is looking for is an individual is being physically abused by a custodian, and that custodian has not been removed from the environment. So that victim could continue to receive abuse or neglect. So we want to make sure that immediate protections have been put in place for the victim. The name, title, and contact information of others who may have the same information as you, and any other information that may assist with the investigation or the review of the incident. Because, this in some instances, this is the only opportunity that we have to speak to the reporter if they choose to remain anonymous. So we need every bit of information that we can possibly get to ensure that that incident is properly classified and assigned to the correct entity to investigate. We do have a multiple reporter requirement. Multiple reports regarding the same incident are not required if the mandated reporter knows that the incident was reported to the Justice Center and they were named in a report as a person with knowledge about the incident. That was put in place a few years after the Justice Center's creation, because we were receiving, 4, 5, 6, maybe 10 calls all about the same incident. And it was taxing not only on our call center, but it was also very taxing on the agencies that had to have staff come off the floor and make reports. So we did go to the multiple reporter requirement. All right, so after the call is completed, our agents are going to input all the information into our VPCR. They are going to put together a chronological narrative of all of the details of the incident. And then that incident is then going to go to a supervisor where a quality assurance check is going to be done. And then it's going to be classified, and it could be classified as either a reportable incident or a non-reportable incident. Our reportable incidents are those incidents involving abuse and neglect or a significant incident. The non-reportables are either classified as not an incident, and those are the general inquiries. Perhaps somebody, reached the Justice Center hotline in error and they did not intend to call us. We still have that call recorded. We still have an incident number assigned to that call. We need to process it, and that'll go out as not an incident. Also, if someone is calling to get general information about the Justice Center, that, we'll take that call, we'll route them where it needs to go, but then we're going to classify that as not an incident. And then we also have our non-NYJC non-reportable incidents. And these are those instances where a report does not meet the threshold for an abuse and neglect or a significant incident classification. Or it could be that the report is being made about a provider that is not under the jurisdiction of the Justice Center. We do take full reports on those, and then we're going to take those reports and we will either send them out to the SOA that is under our jurisdiction, or we will do our best effort to get them out to an appropriate state oversight agency that may not be under our jurisdiction, but we don't want to let it sit.
Hi, David, I have a couple questions for you from the chat.
Sure.
The first is, are DSPs or other staff in provider agencies considered mandated reporters?
They are.
So they should be reporting to us as well. And the next one is, what if the original reporter who made the report to the Justice Center is not able to update the report? Can their supervisor make that update?
They cannot. We can only take updates from the original reporter. However, we will always take a new report, and then based upon the information that we receive in that report, if it's truly an update, it would get linked to the original report and sent out.
Thank you. The last two questions for now are, can you speak further, or anybody on this panel is free to chime in to help out, David, can you speak further about what reasonable suspicion of abuse and neglect means? It's, usually based on your training, your experience, your knowledge of the agency's policies. Those are the things, if you see something and you think that, someone should look into it and prevent it from happening again, that's usually a good call for making a report.
Hi, this is Krista Book. I'm the general counsel here. So the way I would define it kind of is you have a reason to believe. So if you have a reason to believe it, and it's based upon uh, something that is reasonable, then I think to err on the side of caution, it is better to report.
Thank you, Krista. The last question before I let you proceed. If a staff person no longer works at the agency, but they were involved in the incident, is it still a reportable incident to the Justice Center?
It certainly is, yes. Because, we know how this field operates and people can, go from agency to agency. So we want to, if they were the subject of an allegation, we want to know that, we want to investigate that to perhaps prevent them from going to a different agency and doing that same conduct again.
Thank you. I'm gonna get off, but I just want to say DSP, if we use that, it means direct support professional. That's a common term in OPWDD programs. All right, David, carry on.
Yeah. Oh, and just I know every time I do a presentation, Devin yells at me, SOA means State Oversight Agency. That's just one of those terms around here, like DSP, that we use so freely. But SOA, if you hear me say it again, is State Oversight Agency. All right, let's take a look at some numbers from last year. So, in 2023, we took just over 13,000 reports of abuse and neglect. We took 27,869 reports that resulted in a significant incident classification. We did take 1,649 death reports. We did take 31,476 non-Justice Center incidents. And this is what I was talking about in the few slides previous. These are those, it's not under our jurisdiction, or it just did not reach that threshold of abuse or neglect or significant incident. But, please be aware that we do send them out, and it's at the agency's discretion whether or not, they're going to investigate that. And then 11,173 people, those were not an incident. And just enough, like if there's a bad connection or if somebody hangs up once they hear our greeting, that would also be considered not an incident. All right, so significant incident classification. Each state agency has unique definitions of significant incidents. Here at the Incident Management Unit, we've got classification guidance documents for all of the SOAs that we cover. And some of those have different definitions for what a significant incident is. And it all comes from their regulatory standards for that agency. So what might be a significant incident for OPWDD is not necessarily a significant incident for OMH and vice versa. So we rely heavily on those classification guidance documents to ensure that we are classifying correctly.
I have a couple more questions before we go into the next question. The first one is, if a staff person called in a report in March, they called in the report, they're the reporter, and they haven't heard, is that, because how long does that take, or does the reporter ever hear back from the Justice Center if they've reported something?
They're not going to hear directly from the Office of Incident Management. I can tell you that all reports that are made are processed and, notifications are sent out to the State Oversight Agency as well as the agency within, 2 to 3 hours. So that report comes in, we're processing it, we're getting it right out the door to ensure that those notifications are met and those safeguards are put in place.
And are incidents that occur between two people receiving services, are those reportable to the Justice Center?
Those are one of the classifications for a significant incident. We have conduct between service recipients as a significant incident on, I believe, just about every one of our state oversight agency classification documents.
Very good. There's a couple questions, spoiler alert, that people are asking about reporting of deaths and investigations, which I'm going to hold off on asking right now. But there was a question about guidance documents for reporting incidents, and the Justice Center's website is full of information about how to report, when to report, and what's reportable. So we encourage you to check it out. All right, allegation review and assignment. Go on.
All right, thank you. All right, so the Office of Incident Management is comprised of 4 different units. And if you're lucky enough to be attending this afternoon session, you'll see me again. So my apologies. But we're going to be talking about the 4 different units. And obviously we have intake. Those are the people that handle the calls. We have our information line, and then we have our 3 business day review unit, which I'll get into. But then we also have our JC assignment and Q team. So they receive all cases of abuse and neglect death that are assigned to the Justice Center. They gather additional case information as needed. They determine the case assignment, and then they ensure notifications are sent to law enforcement and district attorneys. But we will we'll get into that this afternoon a little bit further. So let's talk about those notifications again. So state oversight agencies are notified of all the reports we receive, even those non-NYJCs. So when a case is assigned to a provider for investigation, this notification includes an investigative strategy memo. And the purpose of these strategy memos is to increase the communication between the agencies and the Justice Center by providing directives for reporting pertinent information back to the Justice Center for review and possible reassignment of the original case or the creation of a new case. Second, we want to outline all investigatory questions from the narrative and provide classification-specific guidance for completing an abuse and neglect investigation, specific to the classification type. We have identified strategies for each offense and classification, such as physical abuse and psychological abuse, that can provide a starting point for each investigation. The strategy memo was introduced within the last few years, and I can tell you that the amount of cases that are investigated by the agencies that are sent back for additional information has dropped drastically. This investigative strategy memo that's included in the original case creation really is a roadmap for an investigation, and it ensures that all of the T's are crossed, the I's are dotted, and it really makes for a complete investigation that can be sent off to our Office of General Counsel for closure and not have to go back for additional information. So it's been a great addition here at the Justice Center. And then our 3 business day review classification assessment. This allows the Justice Center to conduct a preliminary review of all allegations using an evidence-based approach. We've got 5 of the 6 providers that are participating in the program, such as, it's OMH, OPWDD, OASAS, OCFS, and SED. And when an incident is sent to our 3 business day review unit, we're going to be reaching out to a point of contact that's already been established, and we're going to be asking them for documentation that will assist in the final classification of that incident. And just to give you an idea, in 2023, there were 4,645 reports that went through our 3 business day review process. And of those 4,000 plus reports, 59% of those reports were reclassified as significant incidents or non-NYJCs. So just think about that. That is 59% of the reports that were originally at face value an abuse and neglect investigation, where we need to have staff be taken out of work, where we need to put a lot of resource into a complete investigation. And of those, we were able to send 59% of those out as either a significant incident or even a non-NYJC report. And just some benefits of a 3-day review assessment: it increases the accuracy of incident classification. And appropriate safety measures are readily enacted, because once we get that report, we don't wait 3 business days to inform the provider that this incident came in. It automatically goes out as a an abuse and neglect, but it's pending review. So notifications go out immediately, and then the agencies and the SOAs can ensure that those safeguards are put in place. It's a reduction in the length of time provider staff are out on admin leave. A decrease in provider staff unnecessarily placed on admin leave. And it narrows the scope for investigative resources, ultimately reducing cycle time for all abuse and neglect investigations. All right. That is
No, you have a couple questions, sorry.
okay.
How do we determine who is going to do the investigation into the allegation of abuse and neglect? You know, whether it be the state oversight agency, provider, or the Justice Center?
The intake unit prides itself on our classification or our guidance documents, and we've got way more than I can count. However, we've got certain criteria that are met, that need to be met for an incident to be investigated by the Justice Center. And then we also have certain criteria for whether it goes out to the agency or the state oversight agency for investigation. So it definitely depends on what type of provider it is. Is it an ICF? Is it a family type home? All of that comes into play. Is it a state operated facility, or is it a voluntary? All that comes into play when we're determining who's going to be assigned the investigation.
Thank you. Would a reporter, someone who makes a report to the Justice Center, ever know if safeguards are put in place?
They may not. That is very well a possibility. And that just further exemplifies the need to get our notifications out as soon as possible.
And just to clarify, is the strategy memo that used for all abuse and neglect cases that are reported to us?
Yeah, it is for all those that are being assigned out to the agency for investigation. And we have specifically formulated memos for each of the different classification types for abuse as well as neglect. And it's a really it's a great dynamic document that is very well put together.
All right. I'm going to turn it over to Tony Ryan now to talk about investigations.
All right. Good morning, everyone. Thank you, Devin. My name is Tony Ryan. I'm the Chief of Investigations here at the New York State Justice Center. So here at the Justice Center investigators, the cases that we are assigned to investigate are any reports that allege or appear to constitute criminal conduct, the most serious and egregious incidents of abuse or neglect, and all abuse neglect incidents in either OASIS and SED programs and all state operated OCFS, OMH, and OPWD facilities. Some investigative facts for us. Many of our Justice Center investigators have previously worked in provider settings, and also quite a few of our investigators and overall staff have family members that are served by providers under our jurisdiction. And we all receive continuous training throughout the year. During the course of investigation, somebody who is named as a subject in the investigation should expect to receive a notification letter notifying them that they are in fact a subject of an investigation. During the course of the investigation, there's many investigative steps that are taken. Those would include the gathering information, gathering of documentation, videos, any medical records that would be relevant to the investigation, any other policies and procedures that would be relevant to the specific allegation. And then we would conduct our interviews of any witnesses, any individuals receiving services, and then of these subject interrogations. We do provide guidance for staff on the New York State Justice Center website. That guidance would include the reporting of incidents, which Dave Freiberg spoke about. It would also outline the investigative process in a little more detail than we're explaining here today. It would also detail the appeals process, and there's also the availability for online training on the Justice Center website. One of the units here that is at the Justice Center, excuse me, that is designed to help both the individuals and their families through an investigation, through a final determination, or if there were some type of criminal proceeding. The individual and family support unit makes referrals and will serve as a liaison. They will promote responsive and efficient communication. They conduct outreach. They track data and information. And in their time here, they have helped over 19,000 unique individuals. Provided here on the slide is our hotline number, our information line number, and also our email address for our support coordinator.
Go on, Tony. I'll wait till after this one.
So also on the New York State Justice Center website is the investigation process, which is outlined here on this slide here.
All right, I just have a couple questions, and I want to clarify some things. There's been a few questions in the chat about how come I haven't heard about a case. I've got somebody out on leave. I'd like to know what's going on. How long does it take for things to get closed? We're going to drop in the chat, and everyone who attends this will get this, a list of our supervising investigators. We always say to people, if you're not hearing from the Justice Center and you need to know something to keep your provider agency going, always call. Don't suffer in silence. You know, sometimes there may be a reason that it's taking a long time, but we can we'll get back to you with the answers. So some of these are very case specific, and we'd be happy to answer your questions, and there's contact information at the end of the PowerPoint and throughout. And one last question for David Freiberg, maybe. Can the abuse neglect strategy memos be found on our website anywhere? I think I lost David. Oh.
No, I'm here. Sorry. No, they're not anywhere on the website. However, they would come across through our notification.
Thank you, David. All right, Krista Book, our general counsel, will carry on from here.
Good morning, everyone. Okay, so I'm going to first talk about case review and closure. So as to a final determination, the Justice Center reviews all investigations and we make a final determination in the case. So what that entails is reviewing all of the evidence, including the interviews, any documentary evidence, and then we make a final determination about whether or not the case is substantiated or unsubstantiated and what category it is. We also notify all of the parties involved and we oversee a corrective action plan. So unsubstantiated, meaning that we did not find that abuse or neglect occurred, or we didn't have enough evidence to show that abuse or neglect occurred. Those cases are unsubstantiated and they are not publicly available and they can't be accessed by future employers. So substantiated means that we did find preponderance of the evidence that abuse or neglect was committed, and that gets classified into one of 4 different categories. Category 4 is one of those. So this is made against a facility or a provider, not a custodian. So this is not against a particular person. So sometimes it's because staff culpability is mitigated by systemic problems at a facility or provider agency. So it could be, you know, lack of overall training, lack of overall staffing or availability, things like that, that we might find that the staff culpability was mitigated. Or it could be that abuse or neglect was found to have been committed or substantiated, but we can't identify the perpetrator despite a thorough investigation. So the examples I like to give for that is, say someone ingested a non-edible object. They become in distress and we take them to the hospital. They have to have surgery and the doctor can say that this ingestion took place, you know, within the last 24 to 72 hours. And despite the fact that we looked at who was the person's level of supervision during all of this time, we weren't able to say who it was that breached that supervision. However, we knew because they were on a one-to-one supervision that it was breached. In that case, we would say this is substantiated as a category 4, but the perpetrator can't be identified. Category 3, this is the vast majority of substantiated findings fall into this category. So category 3 is the lowest of the categories. It is substantiated findings of abuse or neglect, but the conduct does not meet the definition of category 1 or 2 neglect. Category 3 findings are not publicly available and they cannot be accessed by future employers. Category 2 is conduct in which the custodian seriously endangers the health, safety, or welfare of a service recipient. So this is kind of on the scale a more serious level than a category 3 finding. It is one of the levels of abuse or neglect that's in our statute, with the added component of it being seriously endangering to the health, safety, or welfare. Two category 2 findings in a 3-year period results in a category 1 finding and is placement on the staff exclusion list. Now with that, I'm not going to get into it right here because it's a bit nuanced, but they have to occur in a certain way. So you can't commit 2 category 2 findings on the same day and go on the staff exclusion list. The person has to be on notice of their previous category 2 and receive another one to go on the staff exclusion list. Category 2 findings that are not elevated to a category 1, they are also sealed after 5 years. Category 1, there's 14 different types of conduct that's defined in our statute. Mostly what we see more, the very most, are serious physical abuse, sexual abuse. There's also other serious conduct by custodians. So the other one that we might see is more of a neglect in a very severe and serious situation. This does put the staff on the staff exclusion list, meaning that they are barred from working with people with special needs as defined in the statute in New York State. There are some very rare exceptions to that with people who may belong to a union and are on the Category 1 list. The name of staff with a substantiated Category 1 finding, they are not publicly available, so there's no public database. However, as employers or doing a background check to hire people, it would come up on a Justice Center background check to that employer. So I was just saying, individuals on the staff exclusion list are prohibited from being hired by any state-operated, certified, or licensed agency or provider that serve people with special needs. So in the 10 years, almost 11 years that the Justice Center has been in existence, we now have just over 900 people on the staff exclusion list. That is a lifetime bar. More than 320 checks resulted in a provider being notified that the applicant was on or pending placement on the staff exclusion list, meaning people are still going out despite the fact that they're on the staff exclusion list, or the SEL, as we like to call it. Despite the fact that they're on the SEL, they're still trying to reapply in this field. So the background check that is completed prior to being hired is identifying people that have already been determined that they cannot work in this field any longer. So substantiated cases by category. As I said, the vast number are Category 3. As you can see by this pie chart here, 70% of our substantiated cases are Category 3, the lowest level. But to keep that in mind, so on average, 35% of abuse and neglect cases are substantiated. So of the whole of abuse and neglect cases that are called in and classified abuse and neglect by the Justice Center, only 35% of those are substantiated. Of that 35%, 70% are Category 3. Category 2 takes up 24% of that, and Category 4 and 1 are both less than 1%. So it's something that's taken very seriously when we make a case a Category 1 or a Category 4 finding. So at the conclusion of the investigation, we notify the family member, the personal representative, and/or the service recipient in the case. We also notify the provider of the outcome of the investigation, as well as the state oversight agency, the SOA, and the subjects of the case. So everyone receives a letter at the end of it telling them what the resolution of the case is. Corrective action plan, CAP audits. So the Justice Center does conduct audits of some of the corrective action plans for substantiated allegations of abuse or neglect. So the CAP audit finding letters are sent to providers and copied to the SOA to share audit findings and any recommendations that are made to reduce future risk of abuse and neglect and to improve the quality of care.
Hi, Krista. I have just a couple of questions.
Sure.
What's the time frame for the Justice Center to close a case?
So the statute says that cases should be closed within 60 days, barring some circumstance that needs to extend the time. So that does happen, especially in cases that are more complicated, such as a medical case, a death case, a case where we might need medical records, a sexual abuse case. So there's certainly instances where we need to extend the time frame, but 60 days is the time written in the statute, but for some extenuating circumstances.
Thank you. And who makes the decision to put staff out on administrative leave or decide whether to pay them or not when they're on administrative leave?
That is solely in the hands of the provider in connection with the SOA. The Justice Center has absolutely nothing to do with putting staff on leave or determining the status of whether they are paid or not. We do not in any way make that decision.
And last question, does the Justice Center notify other provider agencies if someone is, has committed to category 2 findings and then, within the time period and then ends up on a staff exclusion list?
So if someone is being placed on the staff exclusion list and they're still working, the employer that they work for now, where they're actively working, would be notified of a category 1 and their placement on the staff exclusion list. And then, as I said, if that person were to try to apply to a job working with people with special needs in the future, that would also result in a hit on any criminal background check that's conducted in the future.
And actually, one last question. If
Sure.
somebody is placed on a staff exclusion list and has a category 1 finding, is the provider agency required to terminate their employment?
They cannot work, yes, but for, as I said, there are some limited circumstances within state operated facilities where someone goes to a hearing and they may, in rare circumstances, be able to continue on working with a category 1 finding. However, it's just in that specific job. They would not be able to go out and get a new job working with people with special needs. But as I said, that's extremely rare.
Thank you. Carry on.
Thank you. All right, so let's talk about the appeals process. The subject of a substantiated report of abuse or neglect, regardless of the category, has the right to challenge the findings. We call it a request for amendment, meaning they want to request to amend the finding within 30 days of their letter. This doesn't have to be anything formal. We just need notice from the subject or an attorney, if they have one, stating that they wish to request that the findings be amended. So no specific form is required. So you just, we gave kind of an example here. Within 30 days of the determination letter, put your VPCR case serial number. We could find it even if you didn't, but it's very helpful if you do. To whom it may concern, I want to appeal. You may include the reasons why, but you don't need to. Kind regards, Jesse Pinkman. So that's as basic as it can be. Like I said, the most important parts are within the 30 days of determination. The time period does expire, so you don't want to go beyond that 30 days. We have over here late notice of appeal in extraordinary circumstances, and I kind of want to emphasize that it's extraordinary circumstances. The executive director may accept a late request for amendment. But you don't want to rely on that. And as I said, the statute is kind of strict as to who gets it. So it's really important that within those 30 days, if you want to appeal, you send in notice. And as I said, it can be just as basic as I want to appeal, and that gets it in time and stops the clock. So there's a multi-stage appeal process. First is the request for an appeal. So sending in that letter or email, whatever it might be. Then it goes to a separate unit in the Justice Center. It's called the de novo unit. And what they do is they take an independent look at the entire case. So the Office of Case Closure, as well as the administrative law unit, so they both are under the Office of General Counsel. However, the de novo unit is not. They're an independent of counsel's office. And so when an appeal is made, they take a fresh look at the case. They look through everything to see if they agree that there was a preponderance of the evidence that supports an abuse or neglect finding. So they make their own determination. They can amend the determination. They could change the category level. They could unsubstantiate it. They have pretty much free reign to be able to adjust the category level or change the outcome. What cannot happen though is you can't get a more serious finding after appeal. So if you have a category 3 finding, it's reviewed and someone determines, this should have really been a category 2. It doesn't go up. It can only go down. So it can only go down or it can only go unsubstantiated. It can't later be decided, oh, this should have been a category 1, outside of additional evidence coming forward, an entire case being reopened, which is extraordinarily rare. If the appeal is denied, so the de novo unit says, yes, we agree that this should have been a substantiated category 3 neglect. We're going to leave it as is. That means it would go toward the administrative litigation unit. There would be a pretrial conference and some other procedures, and then it would be set down for a hearing in front of an administrative law judge. So potential outcomes are the original finding is upheld. So meaning that the fact that it was substantiated and the category level and what type of abuse or neglect it is upheld. It could be amending the substantiation by reducing the category level. As I said, never increase, but it could be that you have a category 1 or a category 2, and after hearing, the judge decides that the 1 should have actually been a 2 or even a 3. That could be a potential outcome. Could also be that maybe someone was substantiated for physical abuse and neglect, and after hearing, the judge says, no, this was just neglect, not physical abuse. You didn't meet all the elements of that one. Work findings could be entirely unsubstantiated, and then it would be a sealed record that's not accessible. So here's just our website for the appeals process guidance. You can go right here on our website, go to the provider and staff tab that you see what you need to know about the appeals process, and it will kind of break it down for you step by step. It looks like you can also scan it with your phone if you'd like.
Before we go into break, I just have a couple questions. Krista,
Sure.
can a parent ever make an appeal, a determination?
Can a parent? No, they cannot. This is solely for the subject to appeal their finding. However, a parent is free to reach out and ask about the determination or get clarification on it.
Thank you. And if somebody is successful in appealing a category 1 finding and it's overturned, is their name removed from the staff exclusion list?
Yes, it is.
All right.
In fact, as someone is going to appeal a category 1 finding, they're not fully placed on the list, and until the appeal timeframe has either expired or their appeal is through. So what we say is they are pending placement on the staff exclusion list. That would still result in a hit if an employer were to reach out. We would have to notify this person is pending placement on the staff exclusion list, but their name is not fully on that list until either the appeal time runs out or the appeal is decided.
Yes. And a provider can appeal a category 4 finding because that's who it's made against.
Yes.
All right, we're back. Take it away, Sarah Delmarter.
Thanks so much. Good morning, and thank you for the opportunity to speak with our provider community about Justice Center mortality reviews. I'm Sarah Delmarter, the director of the Justice Center's Mortality Review Unit, and I represent a team of dedicated and knowledgeable investigators and nurses who conduct our reviews. This is going to be a very brief overview, and I encourage folks to go ahead and reach out directly as needed for case-specific questions or procedural questions. I'm always here. So under the Justice Center statute, there was a piece carved out that was specific to death reports, and it was separate and apart from reporting reportable incidents. And it required that deaths in residential settings or inpatient settings that are licensed, operated, or certified by OPW, OASAS, OCFS, or OMH need to be reported to the Justice Center. So these deaths need reported as a matter of course, regardless of whether there's an allegation or a reportable attached to it. And then state oversight agency regulations additionally further defined deaths of folks who had been discharged 30 days or less when they passed away. We wanted to take a minute to talk about the provider's roles in these death reports. The first obligation in the statute is that the provider makes a report to the VPCR as soon as there's an awareness of the death. If the person's in your care and you're aware of it immediately, those phone calls come in the same business day, the next business day, and we receive those reports of death. Sometimes if the person has been discharged from your care, you might not learn of the death right away, but the obligation is as soon as you're aware of that death. Then in addition to making that call report or electronic form report to the VPCR, there's an additional requirement of the provider, and that's to complete a report of death form that needs submitted to the Justice Center within 5 business days. I wanted to take a brief minute to talk about that report of death form. For those of you in OPWDD, it's embedded inside your IRMA incident management. In OMH, it's embedded in your NYMERS incident management. The form's also a direct link on our Justice Center provider website, public website, and it gives us additional information about the person's care and needs and symptoms in the last 90 days, their medications, their diagnoses. It helps us start our mortality assessment. Now, the requirement is that it's completed within 5 business days, but I want to give a caveat to that. If within 5 business days, you don't have enough details to complete the form and you find yourself checking unknown for everything, we'd rather you give us a call and take an extra day or two to work with your nurses or your medical records department to get that additional information. So although the 5 business days is really in there to help you give us additional information as quickly as possible, it was never meant to fulfill the requirement by putting their name and date of death and checking unknown for a whole bunch of things that maybe you don't have the answers to yet. So I did want to just point that out, that if it takes a little bit longer than 5 days to give us a more detailed review, that's okay. And then last, the provider's role is to conduct their own mortality and incident review activities in accordance with your state licensing agency's regulations and guidance. So you're expected to go ahead and perform your incident management activities for this death. Now, that said, in the event that death involved an allegation of abuse or neglect that led to you receiving forbearance, then you have forbearance because there's a reportable incident, and that follows any abuse neglect case, regardless of whether the person passed away or not. But I think it's important that providers know, don't assume forbearance. When you learn that the Justice Center is conducting an administrative mortality assessment, it's a concurrent review with no forbearance. In fact, we rely on you to do your part and share your findings with us. We reach out, we attempt to establish relationships in the life of the case, because then we know what you're looking at is maybe your investigative question for the death, what records you're collecting, you know what we might need to see, and we can work towards ensuring that both of our assessments come to conclusions that either nothing needs to be done differently or there are indeed recommendations that should be made to make care better. In the event you find a reportable incident in the course of your death investigation at your agency, you find a breach in duty. What happened does not match what was supposed to happen by policy, by doctor's order, by plan of nursing services, or you find an other reportable event, such as a choking on food or an injury with hospitalization. Don't wait to memorialize it in the end in your investigation for your incident review. You've now identified a reportable incident that needs reported back to the Justice Center. Reporting that back when you find it allows intake to then start the process over to make sure that that death is classified at the correct level and being investigated by the correct body. So if you find a reportable in the course of your investigation, pause your investigation, whether it's talking to your leadership as an investigator, your QA, whether it's reaching out to our unit and saying, hey, we found this, we think it's reportable, or whether you're confident that you've identified a reportable and you make a call back. Please don't wait till the end of your mortality review, your investigation, to identify these breaches in duty that needed reclassified. This represents the number of administrative mortality cases created for mortality assessment by year. It's no surprise that COVID hit our providers and the people they serve very hard with mortalities in 2020. And the numbers have come down a bit since then. But our team of less than 15 review these deaths each year. So 1647 in 2023 was still a pretty high number for our team. But thankfully it has come down since COVID. Of the deaths reported, about 15% of the deaths that we close on mortality assessment require some kind of JC intervention. So by some kind of intervention, that means either a reportable incident was identified, classified, and received the right level of investigation, significant reportable incident, abuse, neglect, and they may or may not have contributed or potentially contributed to the death. But about 15%, we either find a reportable incident that needs reported back and investigated, or we make a complaint to DOH because some portion of their care fell under a Department of Health certified provider, such as an ambulance, an emergency room, or a nursing home, or we've issued a letter of concern. We share with the provider and the state oversight agency our finding that there's room for improvement and a recommendation that kind of draws the provider to standards that we're seeing in other agencies that are finding the same challenge. So again, about 15% of those deaths each year need some kind of intervention on our part, some kind of advocacy to support the agency in identifying and getting a reportable incident investigated, advocating that Department of Health take a look at their role, or directly issuing a letter of concern with recommendations. So how do we do this? Many of our mortality assessments are a closed on assessment without need for further review. Death is part of the life cycle, and we receive stories of people who've passed and their supporting information that may show that they had known diagnoses under treatment, and these were expected or anticipated deaths. We are able to use the incident call reports, the completed report of death form that you guys send in a few days later, some select provider incident review materials, and sometimes some provider follow-up inquiries. We might call and ask for additional details or additional explanations. We might have to reach out to non-covered providers such as medical examiners or ERs or ambulances and 911 calls to help us get the picture. And then we do our best to get the official cause and manner of death. Occasionally a death occurs out of state and we have to proceed without that information. But for the most part, we've built really good relationships with our county coroners and medical examiners, with New York State's database for vital statistics for death certificates, and then with New York City's vital statistics for death certificates. But sometimes the cases have outstanding concerns after our initial assessment. We may have to delegate reportable incident investigations. As I mentioned before, we could identify, or the provider could identify, a breach in duty that requires a classification as a significant reportable incident or abuse neglect. We could also close with those letters of recommendation. But then we have one other tool in our toolbox that we call a full mortality review. A full mortality review simply means that we need to use two more tools in our toolbox to do our assessment. One is a potential site visit with interviews to really understand the situation of what happened and or the way the provider provides services. And then two, we may utilize our medical review board, a board of docs that I'll talk a little bit more later, to help us understand the situation medically and or to help us make the best recommendations. Some of the areas that have led to closure letters with recommendations really come from drilling down into three areas of the mortality case. One is the emergency response. We're looking closely at if staff were able, if they had the resources and the training to provide a timely and appropriate response when they come on scene to a life-threatening emergency. Two, we're looking at if staff and those on call and those medical providers who interacted with the decedent were responding to earlier symptoms in the way they were expected to. So what was observed? Who was it reported to? What were the instructions for monitoring or for transfer of care, and were they followed? And then three, supervision. at the time of the emergency and or at the time the symptoms first emerged was supervision consistent with what was intended for that supervision to detect those symptoms, to prevent that accident, etc. And then we're always looking for the general care in the last 90 days to the last year. Were they linked with at least a primary care provider and received an annual physical? Were they linked with specialty care doctors related to some of their more serious known diagnoses? And those are the basic questions that we're trying to answer when we look at any death. As I mentioned, we have access to a medical review board. It's a volunteer group of up to 15 doctors appointed from the governor's office who are able to support us in directing our assessments when they're medically complex. Our volunteer docs include a forensic pathologist, psychiatry, internal medicine, addictions medicine. The board delegates most of the assessments to our unit, and we make the preliminary determination whether the death appeared unusual or it needs further investigation. There's a reportable or there's a letter of concern. But the board directly provides collective medical opinions and recommendations on the cases that we bring to their monthly meetings. They review approximately 12 to 15 cases a year. They interpret medical findings for us. They help us understand the adequacy of care and discharge planning for certain diagnoses. They often address medication interactions and the risks of polypharmacy, and they often address individual medication monitoring needs and risks related to individual monitoring of meds. So they've been very helpful to us as needed on select cases, and they remain available to us monthly, and we're grateful to their ability to support us. I just wanted to close with some of the high-level SOA specific areas that lead to letters of concern, but not necessarily reportable incidents. In OPW, we are often making comments of plans of nursing services. Either they're unclear, they may conflict with another document, or they may not be sufficient to address the diagnoses with delegated nursing tasks. Yep.
I'm sorry, in the interest of time, I'm gonna ask because we've got
Absolutely.
another section, and I have a couple questions that have come across.
Yep, wonderful.
So, maybe next year we'll do a whole thing on mortality review. Do outpatient programs need to report deaths to us?
So outpatient programs are not required to report these deaths. However, outpatient programs often have information that we can only get from their call reports because they are providing services. So we encourage when they have information that they don't think others have about the death, they may be the first one to know about the death. Sometimes our cases get created from those outpatient calls. So although they're not required, they're very much valued.
Does the death of a person need to be related to their disability to be reported to us?
Absolutely not. By virtue of being a resident or an inpatient within 30 days of death, the death needs reported.
So that's the last question. So if somebody left the residential program and died within 30 days, that would still need to be reported, correct?
Yeah, and just very briefly, we count official discharge. So even if they were out of your care for months to a year, but you did not officially discharge them, the death still needs to be reported.
Okay. Thank you, Sarah.
Thank you.
Paul, I think you're, yeah, got it.
Okay. Hello, everybody. My name is Paula Branca Santos, and I am the Special Prosecutor Inspector General here for the Justice Center. I know we are in the home stretch, so thank you for hanging on with me. I will try and get through all of this in a way that hopefully all of you can understand and not talk super fast. So what does the Office of the Special Prosecutor do? Well, we have a team of very dedicated attorneys, all of whom came from district attorneys' offices in the past, who work hand in hand with really everybody that you've met here today and their valuable teams. I don't always love going last, but in this particular lecture or this particular seminar, I love going last because everybody that you've met here represents a team of hardworking individuals here at the Justice Center who we interact with here in what we call SPIG, Special Prosecutor Inspector General. So it starts out with when a case comes in, and you've heard from Dave in the Incident Management Unit. These cases are broken up into the types of cases that they fall into. One type may be a purely administrative case, which means it goes the admin track. Another type is purely criminal. Those are rare. Most of the time, if a case comes in criminal from the jump, meaning that it has elements of criminality or a crime has been proven, it's because something happened, police showed up, and an arrest was already made. Then in the middle of that are these cases that come in, and when the dedicated investigators in the Incident Management Unit are looking at it, they say, you know what, we're just not sure. We're not sure if it's actually criminal or not. And that's where we fall in. And the cases are put in a bucket of cases that require analysis by the Special Prosecutions Unit. And we look at it to determine, based upon our experience as prosecutors, as to whether or not there are actually elements of criminality under the New York State penal law. And we do that by speaking with the investigators who are assigned to those cases, and also using the analysis that we have come up with in knowing the different statutes that will apply. So the goal here is to work hand in hand also with our local DA's offices. And we really do pride ourselves on developing a network, or having developed a network with our colleagues at different district attorney's offices throughout the state. Because if we feel, prosecutors here over at the Justice Center, if we feel that there are elements of criminality and that this would be a viable prosecution in any one of the district attorney's offices throughout New York State, we will refer that case to the district attorney's office. There is a way for us to switch the category in our internal system, whereby once that switch is made, the DA's office in the jurisdiction where the incident occurred, so if something happens in a facility in the Bronx and we decide that this case should be switched to criminal, now that does not mean that it automatically is going to be a prosecution, but for internal purposes, we switch it to criminal so that the DA's office gets an instant notification. Our prosecutors then follow up immediately with our liaisons at the DA's office, and we let them know what's going on, and we are able to share information for their investigative purposes only, and our criminal investigators are able to share that information with law enforcement as well. Our goal is to work as a team, because when we work as a team, that is the best outcome that could come for the people receiving services and for the providers. So what do we mean by that? We try and get everybody on a call as soon as possible so that we are coordinating interviews so people don't have to be interviewed twice, and so that we are moving expeditiously. Less than 1% of our cases that come in actually do end up being classified as criminal. It doesn't seem that much, and you know what? That's a great thing, right? We don't want cases rising to the level of criminality, but that doesn't mean that they're not serious, and it doesn't mean that they don't deserve a hard look. All that means is that it does not rise to the level of a case that can be proven beyond a reasonable doubt, as opposed to the admin cases, which have a different standard of proof. And I believe that that General Counsel Krista Book mentioned by a preponderance of the evidence. So even though we're talking with district attorney's offices, if they decide to prosecute, or even if they decide not to prosecute, we still have our parallel investigation here. And everything that you heard about. You heard Chief Ryan talk about that. You've heard General Counsel Book talk about that. You've heard Sarah talk about that. We continue to do what we do here, regardless of what the district attorney's office does. We will work with them. It is our duty and responsibility under the statute to assist the district attorney's office in whatever means that they require. And then we continue on with ours. So what does that mean for us? It means we continue to help our investigators get as much evidence as they possibly can so that they can make an informed decision as to whether or not case should be substantiated. It will move forward. And this is when cases do have this element of potential criminality. It is one of those instances that our general counsel, Krista Book, spoke to you about, where cases might take longer to close. And I know that that's frustrating for a lot of providers out there, for subjects, for people receiving services, why things might be taking so long. Criminal cases are one of those examples. If a case is going to the district attorney's office for review, our case often gets held up slightly because of the desire not to have multiple interviews. We're working with other agencies, working with other timeframes. So that would be something, but we are a call away, either the special prosecutor, the investigators, to keep you the individual and family support unit to let you know why that's happening. Don't feel like you're in the dark. We can always give you a reason for why something is happening. And that goes towards anything that's happening on one of our cases to which a special prosecutor might be involved. So the role of the special prosecutor is very nuanced. I could go on and on about what we do. In the interest of time, I'm not, but if anybody has any questions about it, please reach out to any one of us. We have prosecutors that handle cases in all of the different regions. We cover for each other when somebody is out. And again, we will work towards the best resolution with the DA's office and with our own attorneys in the administrative litigation unit and with the investigators. That's also with folks from Sarah's team, as well as our JC SART unit that handles cases that have components of sexual abuse, as all of our attorneys are forensically trained in conducting forensic interviews and have worked or have had experience now with special victims. Okay.
Quick question for you, Paula.
Sure.
So who has, when a case is criminal, who has the control of the final outcome of the case? The DA or the Justice Center, or both?
That's a great question. So initially, the outcome of whether or not something is going to be prosecuted is the DA's office. They will decide whether or not that charges are going to be brought against an individual. That is done in consultation, and I'm happy to say that we really do work well with the DA's offices with us. They do value our opinions, but they are, again, their standard of proof is different. So they are the ones to make the ultimate decision.
And one last question, are financial exploitation cases handled by your unit or the Justice Center?
In some form or fashion, yes. Like, so we will, sometimes we will look at Medicaid fraud, and those cases will be brought to other agencies in addition to the DA's office. But yes, depending on how they are committed and whether or not, again, we believe that they rise to the level of criminality, we will refer those out. And we can also look at them here to see if they meet any of the elements that we have for an administrative case.
Great, thank you.
You're welcome. And now you've heard what we've all said here this morning, right? What we do, how we do it. But wouldn't it be nice if we didn't have to do it? And I know that's very Pollyanna of me, and I know it's something that we like to say in practice. But there are ways, right? And the more we put out there ways to prevent abuse and neglect, hopefully all of these numbers that you saw will come down. And we've come up here, really, I can't take any credit for it at all. It's the wonderful people here who have come up with these prevention tools that are just absolutely amazing. And they are all on our website. So I just want to say that again, please take a look at our website, because you'll find some really, really invaluable resources on there. With respect to these spotlights on prevention and our toolkits, the first thing that the agency came up with is this agency self-assessment. And this is something that the providers can use to come up with some comprehensive type of approach in order to meet the needs of different things that are going on within your particular facility. Again, what you see here is just a little bit. Click on every single tab on that website and you'll find it. And also, before I forget, These spotlights on prevention can also be found on our LinkedIn page. Our agency has a LinkedIn page, and every once in a while, if not monthly, I believe, they have a new spotlight on prevention. There's a new toolkit out there. So please make sure to take a look at that. Follow the Justice Center on LinkedIn so that you can get the updates as they become available. We also have developed best practices for an abuse-free environment, and these best practices really do follow what New York State actually does across the board. Best practices are just that. It's the best way, based upon experience that everybody has gone through in their different jobs, to come up with meeting the demands of the agency, meeting the demands of providers, and how to handle something in as comprehensive a manner as you possibly can in these types of situations, right? So much of what we do is a case-by-case basis, but if we at least have some guideline, if we at least have some natural baseline for how to handle it, then you can go up from there. And then finally, code of conduct. So our code of conduct are ethical guidelines for caring for individuals who are receiving services. And really, we believe that the code of conduct that staff sign each year is one of the most powerful prevention tools that we have. But again, that's if they read it. So please make sure that the code of conduct are really, really stressed and taken to heart. When people sign this code of conduct, they are making a promise to treat the people receiving services with dignity and the respect that they deserve. And they're going to then be following their agency's policies. And if we do that, that's the hallmark of everything that we do here, right? If you start off at the jump saying that you're making a promise and a commitment, then hopefully that leads and guides everybody from there on out. There are various online interactive trainings that you can take on the website, so those are available to you as well. And then we have these prevention toolkits that I also spoke about, which come up on the LinkedIn site as well as online each every, I think, quarter or monthly. Each year, the Justice Center develops these prevention toolkits for the agencies to help you prevent, again, these incidents of abuse or neglect. They're actually based on real life experiences. They're tweaked, obviously, no names are used, no specific providers are used, but again, taking something that happens in everybody's own facility is really something that's going to resonate with you, right? It's going to resonate with you, it's going to resonate with your staff. So to the extent that we are able to come up with scenarios and develop these toolkits based upon those scenarios, we really felt that that would be the best use for you to employ the best practices at your facilities. And everything that you'll find on the website are the ones that we've just done thus far. They are guideposts again, and they can be changed up a bit depending on your needs. So please make sure that you just reach out, let us know what you need, and we will make every best effort to help you adapt it to what works best for you and your staff. And I promised that I would try and go by quickly and stay in the time. So I'm going to leave you with our contact information.
Congratulations, Paula, you brought it home. And